Okay, so welcome back to another episode of Intellectual Property Law. In today's class, we're going to be talking more about trademark infringement and the infringement analysis, specifically in relation to unregistered mark or claims under the section of the Lanham Act that pertains to unregistered marks. So you'll note that we talked previously about the infringement analysis for registered marks. The infringement analysis with respect to unregistered marks is very similar, except that the confusion in question has to go to affiliation, connection, or association, or origin, sponsorship, or approval of goods. In other words, it has to be confusion about the source or affiliation of the product or service in question in relation to the mark at issue. So we'll think about this question in the context of the King of the Mountain Sports case that I asked you to read for today's class. So what happened here? Well, we have a plaintiff, King of the Mountain Sports. They are a sporting apparel company based in Sturgis, South Dakota. So we'll go back to that in a second. In any case, King of the Mountain Sports has been using this mark for quite some time. And they've actually registered a stylized version of the mark in question. In other words, the marks that you see here are in fact registered marks, but they're registered in that form. In other words, they're registered as logos. They're not registered, or they weren't registered at the time, as word marks. In other words, they were registered as images, right? They were registered as the design in question, but they weren't registered as just the words King of the Mountain. So what's the problem? Well, the Jeep company pairs up with a ski racing organization and is sponsoring the Jeep King of the Mountain downhill series, right? So this is a ski race. Jeep is a sponsor. They're sponsoring it in various different contexts. And King of the Mountain Sports says, hey, we're concerned that your use of the term King of the Mountain in your King of the Mountain and downhill series contest is going to cause confusion with us. In other words, people are going to think that we're sponsoring this event. And this is out of keeping with our vision of the brand, right? We're not glitzy. We're not fancy. We're essentially a hunting clothing apparel company that produces like high-end, expensive hunting gear of various kinds of special fabrics and so on and so forth. And essentially they say, we don't want to be associated with this. And we think that there's a risk of confusion because you're using our name in your logo, right? We own King of the Mountain in this context. The contexts are close enough that we're worried about confusion and we want you to stop using it. Okay, so the courts ultimately reject King of the Mountain's claim, both the district court and the 10th Circuit. Why is that? Well, they do this analysis, right? They look at the factors to try to determine whether or not confusion about affiliation or relationship is likely. So first they look to the degree of similarity, right? And King of the Mountain Sports says, look, King of the Mountain, they're the same, totally similar. The court says, no, you have to look at them in context, right? King of the Mountain Sports is used in a particular way, and Jeep and their affiliates are using the term King of the Mountain in a different way, right? Not only is it a different context, right, and framed differently, right, but also the appearance of the logo itself is different, and therefore, in context, consumers would not be confused about the relationship between the two. Likewise, it looks to the intent, says, look, there's no evidence Jeep had any idea King of the Mountain Sports even existed when it chose this name for its series. It said King of the Mountain because it's about going downhill skiing, right? What do you do? Where do you do downhill skiing? On a mountain. And they also looked to the evidence of actual confusion and said, look, you don't have to prove actual confusion as a plaintiff. You can prove likelihood, right? But here we don't really see likelihood or any evidence that people were actually confused. Moreover, the relevant customers in question are likely to understand that these are not the same thing, right? We effectively aren't concerned about the actual risk of confusion under the circumstances. Therefore, we're not going to let this action proceed. Okay, well, let's think as well about the Daystar v. 20th Century Fox case. This is an interesting one because it kind of blends together trademark law and copyright law. So what happened here? Well, Dwight Eisenhower, the Supreme Commander of Allied Forces in Europe, as well as the subsequent President of the United States, wrote a memoir about his experiences during World War II, which was ultimately turned into a film series by a predecessor of the 20th Century Fox company, Crusade in Europe. Okay, popular film series in the late 1940s, 1950s, but they ultimately forget to renew the registration in the film series, right? So the film series, the Crusade in Europe movie that was, shown in various places, falls into the public domain, right? It's no longer protected by copyright. However, this will become important later, the book Crusade in Europe by Dwight D. Eisenhower was renewed. So the copyright in the book, but no copyright in the movie that's the documentary film series that's based on the book, using a lot of material produced by the Army, et cetera, et cetera. So the movie itself actually contains a lot of public domain material, but it also contains elements from the Dwight D. Eisenhower book, essentially like narration lifted from the book itself. Okay, so what happens? 20th Century Fox is selling, and you can see here, copies of Crusade in Europe, ultimately, in the 1990s as a VHS series, right? So kind of nostalgia thing for people who are interested in World War II. Well, Daystar realizes that Crusade in Europe's in the public domain. Great. We can start selling this ourselves, or a version of this ourselves. We don't have to pay for it, right? The movie's in the public domain. It means it's not protected by copyright. It means that anyone can create and sell copies of it without any limitation. So Daystar, you can see in the right here, 1995 Daystar Corporation, affiliated with a bunch of other different related corporation, starts producing this VHS series, World War II, Campaigns in Europe. And basically what they do is they take the material from Crusade in Europe, recut it in various ways, take off all the identifying information about 20th Century Fox as the source, slap their own label on the dang thing, and start selling it themselves, right? They say, well, we're going to mix and match this PD material. We're going to turn it into something we can sell. And this is great. We can have content that we don't have to pay for. And we can make, we can charge people for it who are interested in World War II content. And they even went so far, as you can see here, as to slap a label on the front of the package saying, contains footage from Crusade in Europe. I mean, why not? It's a popular series, right? You got some name recognition there. It's in the public domain. Why not go ahead and advertise it as containing that material to your customers? Well, 20th Century Fox is pissed, right? Because as far as they're concerned, Crusade in Europe is their program. It's the content that belongs to them. So they bring an infringement action against Daystar, both for copyright infringement and for trademark infringement under the Lanham Act. Okay, now, obviously, they can't effectively bring a copyright claim for infringement of the TV material, of the audiovisual material, because it's fallen into the public domain. There's a secondary claim about copyright in the book that comes up later, and I'll touch on that in a moment. The key thing that this case is important for, though, is their trademark action. Okay, so what's 20th Century Fox's theory of trademark infringement here? Well, they refer to it as reverse passing off. What does that mean? Right? Well, passing off is a kind of fancy trademark way of saying counterfeit, right? You're passing something off if you're pretending that it comes from one source, but actually comes from another source. So if you go down to Canal Street, right, in New York City, right, and you see a whole bunch of people selling Rolex watches and various kinds of Louis Vuitton and whatnot, and it's dirt cheap. Right? Well, is it real Rolex watches or real Louis Vuitton? Of course not. It's all fake. It's fake material that's made to look like the real thing. It's counterfeits that are being sold as if they're real. And of course, no one's really surprised. Everyone goes to Canal Street expecting to buy counterfeit goods, but nonetheless, that's a form of passing off, because people are selling one product, pretending that it comes from a source that it actually doesn't, when it's actually a counterfeit product that came from somewhere entirely different. Okay, but that's not what 20th Century Fox is claiming here. Right? What 20th Century Fox is claiming here is saying, Daystar, you're lying about the source of this material. You're claiming that you produced it. You're putting your label on the front. You're putting your copyright sign on the bottom of the box, but you didn't actually make it. This is material that we created. We put this series together. We went out and actually found all this public domain footage and cobbled it together into a documentary film series along with some narration from President Eisenhower. But we made this, not you. And you're not entitled to tell people you made it when you didn't, right? So it's reverse passing off because you're not lying by saying we produced this. In other words, it's not a counterfeit of our product. You're lying by saying you produced that, and you're not allowed to do that. Well, the Supreme Court is a little bit puzzled by the entire circumstance, but ultimately says, look, if the copyrighted material has fallen into the public domain, then anyone's entitled to use it in any way they want to. Right? So Daystar is perfectly entitled to use public domain material and even claim it for itself, right? So the problem here is that 20th Century Fox is trying to shoehorn what amounts to a copyright claim into a trademark infringement claim. And the Supreme Court essentially says, when we talk about misleading about source, that's not what we mean. We don't mean source in the terms of authorship. We mean source in the terms of who's selling the product, right? So it's true that 20th Century Fox is the corporate author of the original material in question, but the source of World War II campaigns in Europe, the VHS set, is truthfully Daystar. Daystar took the PD material and repackaged it in a new form. Therefore, Daystar is not reverse passing off. Daystar is telling the truth. They're the ones who are selling this product, not 20th Century Fox. So there's no reverse passing off problem. And in effect, what the Supreme Court is sort of alluding to is basically 20th Century Fox is accusing Daystar of plagiarism, or a version of plagiarism, by lying about creating the material themselves. And the court says it just doesn't matter, right? Public domain means never having to say you're sorry. Daystar is allowed to repackage public domain material under its own name, and you can't stop them. Now, of course, part of the irony here is a lot of this material was public domain even when 20th Century Fox used it in the first place. After all, it was created by the Army, right? Created by the federal government. That was public domain from the get-go. So, 20th Century Fox is, reaching a little bit from in the first instance by saying that they own this material at all. In fact, if anything, what 20th Century Fox actually owned a copyright in the original product, and the only thing they could have owned a copyright in the original product, was their creative choices in terms of, selecting and arranging the materials in question, as well as the material contributed by General Eisenhower. And that ended up being Daystar's real downfall. So what was the problem here? Ultimately, Daystar lost in a copyright claim on the grounds that they continued to incorporate narration material derived from Eisenhower's book. And the lower courts ultimately found that Eisenhower's book had actually been a work made for hire, commissioned by 20th Century Fox or related companies for the purpose of making this product. Therefore, they were a copyright owner in the narration, and by copying the narration into their video series, Daystar had infringed upon 20th Century Fox's copyright, not in the audiovisual work, but in the literary work that constituted the ultimate narration used in the work in question. A little bit of a roundabout method of getting there, and one could be forgiven for being a little suspicious that maybe Daystar kind of got screwed under the circumstances, because that's a pretty big stretch for a copyright claim. But nevertheless, the trademark infringement claim failed precisely because there was no misleading about source. Daystar was truthfully claiming to be the source of what it believed to be public domain material in question.